The Guide to Trustee Succession and Resignation. Trustee succession is simply the process by which a new trustee takes over the role of managing a trust for another trustee. Trustee succession may occur when a trustee passes away, becomes incapacitated, resigns, declines, or is removed as a trustee. What is trustee succession? The term trustee succession simply refers to the process of having a new or successor trustee take over. Many trusts are managed by the person who created them while they're still alive and have capacity. When that original trustee dies or becomes incapacitated, then a successor trustee takes over. Most commonly, successor trustees are the creator's spouse, an adult child, or an experienced professional trustee. Can I appoint a successor trustee while I'm still alive? Yeah, sure. You can appoint a successor trustee while you're still alive. Successor trustees are appointed according to the terms of the trust instrument. As the creator of the trust, you can specify whoever you want to serve as a successor trustee to take over administration of the trust when you pass away or when you become incapacitated. And if you want to specify a different successor trustee, you might be able to amend the trust to name the person you want. What is trustee resignation? The term trustee resignation refers to the steps a trustee can take if they no longer want to serve as trustee. The California Probate Code only allows a trustee to resign as trustee under specific methods. So in some situations, offering a resignation might not be enough. If you want to resign as the trustee of a trust, you should always consult an experienced trust attorney to ensure you're following the proper steps to make sure your resignation is effective. How do I resign as trustee? Under the California Probate Code, a trustee can only resign by one of the following methods. 1, any procedure outlined in the trust instrument. 2, obtaining the consent of the person who can revoke the trust if the trust is revocable. 3, obtaining the consent of all adult beneficiaries if the trust is not revocable. Or 4, obtaining a court order. Most trust instruments include provisions detailing the process for resignation. A common requirement is for the trustee to give written notice of the resignation to either the trust beneficiaries or any co-trustee or successor trustee identified in the document. If the trust instrument has a specific resignation provision, the trustee must follow whatever process is detailed in that instrument, but only if that process is stated to be the exclusive method. What if the trust document does not contain a resignation provision? If the trust document doesn't contain a resignation provision, then the trustee can resign either by obtaining consent from the appropriate parties or by filing a petition with the court. The California probate law allows a trustee to petition the court to accept their resignation as trustee. The court must accept the resignation, but has the discretion to make any other orders necessary to preserve the trust, including appointing a receiver or a temporary trustee. Can a trustee be forced to resign? No, a trustee generally cannot be forced to resign. However, a trustee may be non-consensually removed through court processes in some situations. Sometimes, trustees, when facing removal, will resign voluntarily. Can a trustee be legally removed? Yes, a trustee can be legally removed. The California Probate Code allows a trustee to be removed, either according to the terms of the trust instrument, by the court on its own motion, or on the petition of someone interested in the trust. The probate court can order that a trustee be removed for any good cause. Some of the most common reasons that constitute good cause include 1, when the trustee commits a breach of the trust, 2, when the trustee becomes insolvent or is otherwise unfit to administer the trust, 3, when the trustee fails or declines to act, 4, when the trustee is excessively compensating themselves based on what they're doing, 5, when the trustee is substantially unable to properly execute their duties for any reason. The trust instrument may identify other grounds for removal according to the processes outlined in that specific document. Some trust documents also allow the beneficiaries or a third party to remove and replace the trustee at their discretion or based on certain circumstances. When should I contact a trust litigation lawyer? As a trustee, you should contact a trust litigation lawyer if you want to resign or if you start to suspect that someone's going to try to remove you. Depending on your situation, a knowledgeable trust litigation attorney can help you understand the requirements for tendering your resignation or defend you against removal. We also recommend that a new trustee consult with a trust litigation lawyer once they're appointed, particularly if it's the first time they're ever serving as trustee. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email. The consultation's always free. Thanks for watching.